Hello everyone and welcome to our data protection webinar. I'm Amanda Glover, an associate at Clark's Legal.
And I'm Rebecca Dowle, a newly qualified solicitor at Clark's Legal. Amanda and I are members of the data protection team.
So today's webinar will cover a variety of topics related to data breaches. We will explain what a data breach is, the rules and procedure surrounding a breach, including your obligations to notify the ICO and data subjects, and appropriate record keeping. We will also discuss the possible repercussions of a data breach, for example, the recent cases attracting fines from the ICO. Finally, we'll move on to discuss how to mitigate against future breaches.
Firstly, we thought it might be worth noting that the legislation which encompasses data breaches in the UK is the General Data Protection Regulation, also known as the UK GDPR. This is retained EU law which sets out how organisations and companies must use personal data. Furthermore, data protection is regulated by the Information Commissioner's Office, or the ICO for short. The ICO is an independent authority responsible for overseeing and enforcing data protection laws and promoting information rights.
So let's begin the webinar today by considering what a personal data breach is. The ICO define a personal data breach as a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed in connection with the provision of a public electronic communications service. Often, when we think of a data breach, we think of an unauthorized party gaining access to personal data, and this would indeed be a data breach. However, the definition is actually much wider than this and will cover situations where personal data is lost, made unavailable, destroyed, corrupted, or where it's disclosed or accessed without authorization. I should add that when we talk about personal data here, we're talking about information that relates to an identified or identifiable living individual. Deciding if someone is identifiable involves looking for identifiers such as a person's name, an identification number, location data, an online identifier, and also factors specific to an individual's physical, psychological, genetic, mental, economic, cultural, or societal identity. So it's quite wide, much wider than just someone's name. It may be, for example, that physical descriptions or reference to job titles would be identifiers provided the description or title was sufficiently unique, even if the person's name has not also been used.
So moving on to rules on data breaches, the ICO say that when a suspected data breach happens, you should quickly establish whether a personal data breach has occurred, and if so, promptly take steps to address it, including telling the ICO if required. The ICO provides guidance to organisations on data protection breaches and will explore each of this in more detail. Procedure. So how should you respond to a personal data breach? The first thing to do is not to panic, and it's probably easier said than done when you discover a potential breach, but it's important that those dealing with the breach act promptly and clearly to mitigate the potential risks and impact. Remember also that not all breaches will result in formal action. Moving on to start the timer. If a personal data breach passes the reporting threshold, you are required by law to notify the RTO without undue delay, and in any event, no later than 72 hours after becoming aware of the breach. It's important, therefore, that you keep a note of when you first became aware of the breach. It's a good idea to also keep a log to document what has happened, why, the people and data involved, the likely impact and your actions taken, even though you may not need to report anything. Next, you want to find out what's happened. Gather all the information as soon as you can. Document it in your log as you learn more about the situation. It is good practice for organisations to have clear policies and training in place for their employees. This is so that the employees are able to recognise data breaches and know how to report these promptly to the correct person. This allows the appropriate people to become aware of the incident promptly. As part of this, you need to determine if personal data is involved.
The next recommendation from the ICO guidance is to try to contain the breach. Once you have figured out what happened and what personal data has been affected, you can work out if you can fix the problem. So for instance, if data has been sent to someone by mistake, such as information being sent to the wrong email recipient, can you retrieve the email before it's opened, or can the person be contacted and asked to destroy the email without reviewing it? In the event of a cyber attack, you're likely to want to take steps to secure your system, including restricting access to systems and updating passwords. Next, you want to assess the risk of harm. Even if you do not have all of the information yet, you should begin considering the impact of the breach and making a risk assessment based on what you know. Assess any possible harm or damage that could have resulted from the data breach or could occur in the future. You'll also need to think about what personal information is involved in the breach, the number of people who will be affected, and what harm may come to them as a result of the breach. If there is a risk to people's rights and freedoms, then you'll need to report the incident to the ICO within the 72-hour timeframe. If there isn't a risk, then you'll not need to report this, but you should keep a record of the reasons for your decision in case this is questioned later. We will talk through this report to the ICO in more detail in just a moment. After you've considered the risk and whether to report this to the ICO, you want to act to protect those affected. If a breach is likely to result in a high risk to the rights and freedoms of individuals, you must inform the data subject's concerns without undue delay. One of the main reasons for doing this is so that they can take steps to protect themselves from the impact of the breach. We will go into detail shortly about what you should tell them about the breach itself, but you can also use this opportunity to help them protect themselves further. For example, you may be able to give guidance about resetting their passwords or choosing stronger passwords. In a banking scenario, you could inform the individual to contact their bank immediately and follow the bank's guidance. Once you believe you've done everything you can, and if the breach is reportable, you should submit your report to the ICO. We will talk through this report in more detail shortly. Finally, as with any security incident, you should review and consider your practices and processes going forward to minimise the risk of a similar incident occurring again. So this may include training on data protection, support and supervision mechanisms for people new to their roles, encouraging the principle of double-checking email addresses and information being sent to others, encouraging data breach reporting by creating a template breach form or online notification process, and implementing greater security controls. Okay, so we've covered what to do when a breach is discovered. Rebecca will now go into more detail about the duty to notify the ICO of the breach.
Thank you, Amanda. As you can see there, a notification to the ICO is triggered when a breach is likely to result in a risk to an individual's rights and freedoms, and this obligation falls on the data controller. This needs to be assessed on a case-by-case basis. To determine whether to report the breach to the ICO, you should consider the circumstances surrounding the breach and take into account the following factors: the type of breach, the nature, sensitivity and volume of personal data, how easy it is to identify the individuals from the data, how severe are the consequences, whether the individuals have any specific characteristics which pose a greater risk, such as a child or a vulnerable adult, the number of people affected, and any special characteristics of the company. You will need to make a judgment call to determine the seriousness and possible risks of the breach. If you choose not to report, you should make sure you record any decisions that you make and keep any relevant information in order to support your decision that there is no risk to the rights and freedoms of individuals. The ICO provides some examples to assist businesses. It refers to situations where, for example, a debt insolvency agent emails a vulnerable new client's file in error to a colleague in a different department. The colleague who received the file immediately deletes the email and informs the sender of the error. The sender and recipient both work to the same security measures and have had training. The ICO says that it is unlikely here that this would need to be reported to the ICO. On the other hand, it gives an example of a data controller sending paperwork to a child's birth parents without redacting the adoptive parents' names and address. This would present a high risk to the adoptive parent's safety and should be reported to both the ICO and the adoptive parents. Okay, so how long before you need to report? Now, I've mentioned this one previously. You must notify the ICO without undue delay and within 72 hours of becoming aware of the breach. It will not always be possible to investigate a breach fully within this timeframe, and you are permitted in some circumstances to send information to the ICO in phases, but you should explain the delay and give an indication of when further information will be provided. It is worth noting here that if you were the person to discover the breach, it is not down to you solely to report to the ICO. You should follow your company procedure, and reporting should usually come from the company's data protection officer or person responsible for data protection. So what needs to be reported? The report to the ICO should include a description of the nature and personal data breach, including, where possible, the categories and approximate number of individuals and personal data records concerned, the name and contact details of the data protection officer or other contact point where more information can be obtained, a description of the likely consequences of the personal data breach, and a description of the measures taken or proposed to be taken to deal with the personal data breach, and where appropriate, the measures taken to mitigate any possible adverse effects. Finally, let's look how you notify the ICO. Notifications can be made online via the ICO's website. If you are dealing with a serious cyber incident, you may also need to report to the National Cyber Security Centre, and you can find guidance on their website. You can find the link to that on the slide now. Okay, great. So Amanda will now talk you through your obligations to notify the data subjects.
Thanks, Rebecca. Yeah, so the requirement to communicate a data breach to individuals is triggered where a breach is likely to result in a high risk to their rights and freedoms. So informing an individual of a breach has a higher threshold than informing the ICO. So you want to be asking yourself, is the breach likely to adversely affect the personal data or privacy of the data subject? If the impact of the breach is more severe, the risk is higher. If the likelihood of the consequences is greater, then again, the risk is higher. You need to promptly inform those affected, particularly if there is a chance you can mitigate the risk in doing so by, for example, making them aware and getting them to take action. For example, contacting their bank if there has been a breach involving their financial details. Organisations can determine if communication to individuals is necessary by using the same factors that Rebecca listed for notifications to the ICO. Again, the ICO gives some examples to assist businesses. One such example is if a hospital suffers a breach that results in accidental disclosure of patient records. There's likely to be a significant impact on the affected individuals because of the sensitivity of the data and their confidential medical details becoming known to others. They would need to be informed in this scenario. However, if a medical professional sends incorrect medical records to another professional, they inform the sender immediately and delete the information securely. It's unlikely that they need to be informed. Just to quickly discuss what you would include in the communication to individuals. So you want to give the name and contact details of your data protection officer or other person who the individual could contact to get more information. Details of the potential consequences of the breach and an explanation of steps taken or planned to address the data breach, together with how you would mitigate any potential adverse effects. It's highly recommended that you seek legal advice if you are notifying data subjects of a personal data breach. Okay, next we want to touch briefly on record keeping. Any breaches of personal data that have occurred at the company should be documented. These should be kept in a data breach log or record. The information recorded should say 1. The nature of the breach, the consequences of the breach, and the remedial action taken at the time. The ICO suggests a template log which can be found on its website. You can just see it on the screen now as an example.
Okay, so turning now to potential repercussions if you fail to report a breach to the ICO. Well, the ICO has the power to issue fines for infringing on data protection law, including the failure to report a breach. There are two thresholds worth mentioning here. The first one is that if you do not report a breach to the ICO within the specified timeframe, you risk a hefty penalty of up to 8.7 million, or fines equivalent to 2% of your global annual turnover. This is known as the standard maximum. However, under Article 5 of the UK GDPR and Section 34 of the Data Protection Act 2018, violations of data protection principles carry fines of up to 17.4 million, or 4% of your annual turnover. Now, it's worth noting here that as the data protection principles contain integrity and confidentiality principles, which obligate businesses to use the necessary security measures to prevent data breaches, it is unclear which fine threshold would apply in relation to a breach of these security measures. Therefore, please bear in mind that under certain circumstances, if you fail to have in place an appropriate plan in responding to data breaches, it could result in a fine that triggers the higher threshold. That is why it's very important to seek legal advice as early as possible if you believe that there has been a breach of personal data. It's also important to bear in mind that as well as financial sanctions for breaches and failing to report, there are other repercussions for companies and also individuals when there's a data breach. For companies, this could include reputational damage, an impact on operations and finances when dealing with the breach, and legal claims for those affected. For individuals, the data breach could lead to a loss of control of their data, identity theft, emotional stress, and financial loss.
Following on from that, we will now highlight some of the recent fines imposed by the ICO in relation to data breaches. So over the years, the ICO has handed out large penalties for data breaches where companies have failed to protect customer data. In particular, between the years of 2020 and 2021, the ICO issued a record amount of 42 million in fines, which was 1,580% more than on the previous year. Some of the top fines then were against British Airways, who were fined 20 million in 2020 for failing to protect the personal data of more than 400,000 customers. Marriott International was fined 18.4 million in 2020 for the failure to keep millions of customers' data secure. And you may have heard of the £12.7 million fine to TikTok last year as a result of the company illegally processing the data of over 1 million children under the age of 13. More recently, in February this year, the Ministry of Defence was issued with a £700,000 fine, although this was reduced to £350,000 on the basis that it is a public body. And that was in respect of a data breach when it inadvertently disclosed 265 unique email addresses by including these in the to field instead of the BCC field. As highlighted in its penalty notice, the factors that the ICO will take into account when deciding whether to issue fines include the nature and gravity of the infringement, taking into account the nature, scope, and purpose of the processing, the number of data subjects affected, and the level of damage suffered by them. It will also look at factors like whether the breach was intentional or negligent, the manner in which the breach became known, whether there are previous infringements against the data controller, whether it has failed to take measures recommended in the past, and the degree of cooperation it has with the ICO following the report. It will examine the action of the data controller has taken to mitigate the damage and any other mitigating or aggravating factors that it considers relevant. These are just some of the examples of the fines issued by the ICO and given to companies who have fallen short of the data protection laws. So as I mentioned earlier, it's highly recommended that you seek legal advice early on before it's too late and you get hit with hefty fines.
So lastly, we move on to mitigation. We've touched on a few of these points already. But the best way to prevent future breaches is to ensure staff are properly trained on data protection obligations and how to handle data appropriately and securely. Regular training programs should include modules on data breaches, especially for those employees who have greater access to personal data, such as IT and HR staff. Training should also be given on recognising data breaches and reporting them to ensure any breaches are identified promptly and can be immediately contained. Linked to this, it is also a good idea to have clear policies and procedures in place on data protection. This is something the ICO often comment on when issuing fines. There should be checks in place to double check information is being sent out. For example, in emails, the ICO calls this the check twice, send once approach. You should also consider regular testing. This is necessary to find and fix any flaws that there might be in the company's policies and procedures when experiencing a personal data breach. You may need to implement stronger security controls and systems. It is also a good idea to learn from your experience and incorporate any feedback into your organisation's practices in order to better prepare for any future data breaches. Next, make sure you have insurance. Given the potential fines under the UK GDPR, it would be wise for companies to consider whether their insurance covers breaches of personal data, including any direct or indirect losses and potential damages. Now, just on this point, you should be aware that there is currently an issue on the enforceability of insurance indemnities for administrative fines. So I just wanted to flag that to you. Okay, so lastly, you want to ensure your company has a robust data management plan. This is a plan which details how personal data is collected, processed, analysed, preserved, and shared throughout the time period that it is held by the company. Ensuring employees stick to the management plan should aid in avoiding any breaches of personal data in the future. I think overall it is best to be proactive and ensure you have in place robust companies' policies and procedures that hopefully stop any breaches from occurring, or at least have a solid plan of action in place if one does occur.
Thanks for that, Rebecca. So we've come to the end of this webinar. It's just left to say that our data protection team are on hand for any advice you need on data protection issues, including assistance if you're faced with a potential data breach. Please do not hesitate to get in touch.
Thanks, Amanda. And we hope you've enjoyed this webinar today. Thank you all for listening. And if you have any further questions on data breaches, please feel free to submit them either to myself or Amanda, and we will endeavour to get back to you as soon as we can. I've included our email addresses there on the side for you.
Thanks again for watching, everyone. Goodbye.